I now request everyone to give a big round of applause to welcome sir. I would now like to introduce Shri Manoj Potsatji. He is an entrepreneur and corporate leader based in Pune, known for his work in business development, technology, and social impact. He has experience in management consulting, IT, and supply chain functions, having worked with major organizations earlier in his career. He is a founder and director of several ventures, including roles in Sarkar Robotics Private Limited, Sakar Edu Industries Private Limited, and has leadership involvement with the Pune Platform for Collaborative Response Foundation. In addition to his business pursuits, Manoj ji engages with community and social service organizations and has been involved in various volunteer work related to relief efforts in Pune and other initiatives like the very own Pune Samvad. Please give a round of applause to welcome Manoj ji as well. And with us, we have Shri Premji Borse. He is a Deputy Director of DRDO ARD, hailing from Nagpur, and the co-convener of Pravaha Foundation, collaborating with us to make this event a success. So I welcome Premji as well with a round of applause. Sir, now I request Manoj ji to kindly felicitate SK Jain, sir. The felicitation is being done with a memento of Ahilyabai Holkar, symbolizing the theme of our conclave. Thank you, sir. It gives me immense pride and joy to present before you a very special moment of today's gathering. Today, we unveil Nyaya Pravaha, a booklet that is not merely a compilation of ideas but a thoughtful journey towards reclaiming Bharat's Nyaya, Artha, and Rajya, drawing from the depth of our civilizational wisdom and connecting it to contemporary relevance. Nyaya Pravaha is structured into three profound chapters. The first chapter is Nyaya Darshan, exploring the foundational notions of justice in the Bharatiya philosophical tradition. The second chapter, Artha Darshan, reflects upon our traditional understanding of economics and wealth. The third chapter, Rajya Darshan, delves into the statecraft and governance. And now I formally ask SK Jain sir to mark this significant moment to kindly come forward and reveal the Nyaya Pravaha. Thank you, sir, for inaugurating this intellectual offering. The participants would be receiving this booklet each post lunch and then you can view it. Now, as we continue this enriching morning, I would now request Shri Manoj ji, who has been closely associated with this event, to kindly come on stage and share some insights about Pune Samvad.
Namaskar, everyone. A very good morning to all of you. Yesterday, we had a very important day. So I would ask everyone to say with me, Chhatrapati Shivaji Maharaj ki. Yugantar, Pune Samvad, Pravaha and Symbiosis Law College came together to have this very wonderful initiative and a conference to understand and to talk about the Nyaya aspect of a Indian society. That's a Yugantar. Pune Samvad is a vibrant platform started 20 months back, I would say. And it started as a monthly series which brings knowledge, wisdom and information to Punekar through various speakers across Bharat. We have been very successful in bringing renowned speakers, starting from Sai Deepak, Vikram Sampath, late Sri Vivek Devroy. Many speakers has joined this platform and delivered their keynote address, their sessions on various cultural, historical, strategical, business, and whatnot on this Pune Samvad platform. Now, with Pravaha Law Forum and Symbiosis Law College, this two-day conference, which will bring many aspects of Indian constitutions, which will bring many aspects of the Bharat's ancient Nyay Pravaha, which will also bring many aspects of the current educational dimensions of in various law schools, how it happens. It also brings many thoughts among you to deliberate upon while you go back to your institutions to talk about which are those important aspects. We have eminent speakers lined up for this two-day law conclave. We are very fortunate to have S.K. Jain sir, whom we all respect, and he is very known and iconic figure in Pune when it comes to law. His practice of almost 50 years practice, you can imagine, right? The practice of 50 years, living day in and day out about law. So we are very fortunate to have him as a inaugural keynote speaker for today's session. We are all very keen to listen to him and about his experiences, his teachings in courtroom, in society, and also while talking to the judges, while talking to the fellow lawyers, and also understanding our cultural important aspects of a law. So law has been very important aspect of our culture, and we all know, starting from the ancient Harappa, Mohenjo-daro, and also through our various granthas, we identify that how it has been kept as a sacred instrument to deliver justice. And in view of the same, we see the current system, a constitutional system, which has been based on those ethos. Now, when as a lawyer or as a tomorrow's lawyers or a major important aspect of that system, you will be in a power to deliver something, you will be in power to bring something. And this aspect we need to keep in mind that what is our culture. I'll quote something very important which comes from our scriptures, which is known as the basically a Nyaya Sutra. So it's very important, and I like this very often, which talks about the key aspects of Indian Nyaya culture, which says Pramana, Prameya, Sanchay, Prayojan, Dushtant, Siddhantvaya, Tarka, Nirnay, Vad, Jalpa, Vitanda, Hetvabhas, Chala, Jati, Nigraha Sthananna, Tatvajnananni, Shrehas Adigam. Rishi Gautami has actually come up with this sutra on Nyaya. I'll request each one of you, who is a student of a law, to read this, understand the meaning of this, and it is very easy these days with the AI. You can understand the meaning, importance of each word, what is written in these sutras. And once you read this, you will realize that what you go through in daily of your textbook, the ethos, the moral compass of a judiciary system, everything falls under these sutras. So it is very important when we read and when we go through our curriculum in law, it is very important that parallelly we study what has been the Indian cultural importance of a Nyaya Sutra, Nyaya Parampara. We read that, we understand those important figures who has delivered renowned lectures on this. Thank you very much. Best of luck for 2 days conclave, and it will come out with something very important, unique conclave in Pune. Thank you.
Thank you, sir. I now humbly invite Premji to kindly give the introduction about Prabaha Foundation.
So, namaste everyone. Respected dais and those who are off the dais. Let me be very humble to accept the fact that I don't come from the legal background, but as a Jagruk Nagrik, I do have certain concerns when we talk about the legal systems in Bharat. We all know there are issues, and then this particular conference which we are organizing, we will try to address some of these things. And I do see there are a lot of sessions which are basically related to very relevant topics. So I'm here to talk about the Prabha Foundation. We all know that the legal system which we talk about, we have the most important which comes to my mind is the number of cases which are pending, and the legal system which is the most important, I would say, pillars of democracy, along with three others. So this particular system has to be improved, which lot of forums and I would say forums only are trying to do that. But why Prabha? What different and what unique we are doing? So, as a co-convener, as has been mentioned, it's my responsibility to let you know that what is different with Prabha and what we are doing. In a very short period of time, if you see, as Manoj has mentioned, around the same time the Prabha was also initiated, and within a short period of time we have reached to many different law colleges, around 30 plus, and then we have a backing of a lot of the professionals from this particular system. Um, it's a movement which basically was conceived, built, and driven by entirely by students of the legal fraternity. So you have a say here. So all the students who are actually taking education in this legal system, they are the owners of this particular forum. It was basically created to bridge the gap between the academic theory and the practical legal excellence. So we have S.K. Jain sir, who have tremendous experiences in this areas, and then we have novices who are basically studying right now. So there is a gap. So we want to bridge this gap. You have to understand what they have gone through and what kind of experience they have. So they would be sharing all these things. So this is what Prabha is all about, bringing the experience to the novices here. We basically Prabha is to democratize the opportunities and ensure that every law student has a platform to grow. It is very important that sometimes we do feel secluded, sometimes we do feel that nobody is listening to us, but then this is a forum for you. We would definitely listen to you, listen to your concern, listen to your ideas, how we can improve, how we can take this country forward in this particular area. We have, as I mentioned, have grown very rapidly in a short span. As I mentioned, 30 plus law colleges. We have been supported by strong community of practicing advocates who believe in our mission. So it is very important that when you come together and when you join some kind of forum, you need to believe that what they are doing is good for the country as well as for me. So we try to ensure that we take care of these aspects, and the firm belief which we have that together we can make a difference. That is what makes this particular forum different than the other forums. So our primary focus is providing the high quality internship also. We try to ensure that we do give internship to both talented and the underprivileged students who lack the right connections. Many times it happens that many students come from a background wherein they don't have connections. So this is forum when you get connected. We will make sure we try all our best so that you get connected with the right people, right system. We are expanding, definitely. We aim to establish a presence in every law college across the region. We are therefore looking for passionate students to join us as campus ambassadors to lead their respective colleges. We do have a good, you can say, a collegiate, you can call that, of students who are leading in different law colleges here in Pune. But and there is obviously there is no dearth as such of talented students. So we definitely invite them also to join us. And then we are building the futures. We aren't just an organization. We are a support system for the next generation of lawyers. So I request all of you who are here today who have not yet joined the Prabha Forum to get connected. There are a lot of volunteers here who can help you out in this. And I wish this Yugantar best luck for the today and for the tomorrow. There are a lot of exciting sessions. I request all of you to attend this and enrich by the speakers who will be speaking here and sharing their experiences. So it will definitely benefit all of you. Thank you very much and good luck.
Thank you so much, sir. I myself, I come from a law background and from Pune. I have listened so many stories about SK Jain sir and personally listened him speak before. And let me tell you that something or the other you will definitely learn from whatever sir is going to deliver today in his inaugural speech. Every one of us being interested in law directly or indirectly has registered for this conclave with this intention. And from this inaugural speech now, I'm sure that all of us will get something to think upon when we think about law with a new perspective. With this, SK Jain sir, I now, if it is possible, if you want to speak there, we can provide with a mic or kindly give your inaugural speech. Thank you.
Dignitaries on the dais, and future of India or Bharat, my dear students, because as and when I get opportunity, I feel that I should be with the students who are going to shape nation's economy, nation's judicial system, or fabrics of the society to keep it together. And therefore, I say that when we have assembled together with this Yuga Yugantar, Samvad and Symbiosis Society's Law College, it has given me a privilege to have interactions with you. Even though it has been said that I am going to speak, yes, I will also have little interactions before I start with it. I believe that majority of the attendance is of the law students, yes? So then the questions will be few, and if you can give reply, I will be obliged. How many of you spend or give more than 2 hours in a day in the library of the college for reading the theory and basic books? Please raise the hand. Gentlemen, only one person has raised the hand. But I'm happy that you all are honest. Because otherwise, if you have raised the hand, I was not having data that how many of you are going and not going. But this honesty will take you to another height. So don't worry. If you are not, start from tomorrow. How many of you will start from tomorrow at least to give time in the library for enriching your legal knowledge and other parts are concerned? I'm not going to check the catalog or register. I believe in the honesty of my students and my colleagues. And because India is, or Bharat, we say that we work with the belief, we work with the system that we will never lie. So that is the first part of it. Now the second questions which I will put, how many of you read everyday newspaper and there are always articles regarding the courts, judgments and other parts are concerned? How many of you reads the newspaper? Yes, that's correct. Good part. No, I tell you that if you want to be a leader, you have to be a good reader. And therefore, it always, even reading what from various sources, even if a small piece of paper you come across, you may get some quotes or sentence or informations which will help you in your lifetime. And that's why wherever you get the opportunity, sitting on the railway stations, airport, bus stop, or at home, or wherever you go, if you have opportunity to read anything, please read it. Now the third part is that how many of you are conscious about maintaining health from the point of view of good eating, good habits, early risers, and having a yoga or other parts are concerned? Good part of it. Now the questions comes in that why all these things are required. In Pune at present, there are 15,000 advocates. You must have heard. But the advocates who have a practice which society recognize or their briefs are in thumping are not more than 1,000. Rest are good advocates. So do you want to become a lot of this first 1,000 or 14,000? Part of 14,000? 1,000. But then for that purpose, whatever you will get guidance from your college, from your teachers, from your professors, you have to adopt it, the good practices, whatever it may be. And therefore, everybody talks about law reforms, everybody talks good practice, ethical practice, but I am looking at you that not today, tomorrow, you have to, with the help of discussions, with the help of interactions, with the help of your professor's guidance, with the help of your college resources, you all, not one or two, will be either in the trial court, in the high court, or in the Supreme Court, or in whatever field you choose. As a corporate lawyer, as a law firm lawyer, you will be the best for the India, for the Bharat. You must have read yesterday that European Union has opened an office in Delhi to give training to the legal brains and to give them opportunity to call them in their countries and vice versa. Do you think that it's a good thing? Why? And they are trying to make sure that they are better, they are advanced, and they have got good legal system than the India. And which is not correct according to me. I will give you one small example and I will start it. Sometime back I had an occasion to go to US. In one of the restaurant I was sitting. Nothing was particular. One fellow came and he came and sit before me on the table. He said that, do you think that I'm Indian? I said, it appears like that. Because in Chile and all other parts are concerned, the faces are a little bit similar. Then said, I'm not Indian. I said, all right, if you are not, why should you be asking me? He put a second question. What is the average honesty among Indians? I told them that 100 times better than any other country. He was looking at me as if that I was saying something exaggerating or wrong or that part. So I tried to tell him, gentlemen, you must have a little concept of tax payment. And yes, when we ask for the honesty, there are 10 or 15 parameters. Each parameter we have to see. On paying of taxes, maybe that average Indian may get 4 or 5 marks out of 10. US and other part may get 7, 8, 9 marks out of 10. But on other aspects, honesty to the parents, honesty to the society, honesty to the friends, all Indians will get more than 8 or 9 marks out of 10, and you people will not get more than 1 or 2 marks out of 10. And when we take the average, the honesty among Indians is far, far better than any other country. So that is what you should be always equipped with when you talk with others. Now coming back to the today's subject, our beloved Prime Minister Modi ji has a sankalp. It is not his dream that India will be the third largest economy in the near futures. But then if that is what his vision, decisions, or we say sankalp से सिद्धि तक कहते हैं, how we are going to take it. And one of the important part will be that lawyers has to play important role. Why? Because when the things comes for economy, when things come for politics, when things come for education, unless there is a good law system, justice delivery system, it will not be possible. And therefore, young candidates or law students, you will have an important role to play in whatever best possible manner. And so far as your legal education is concerned, I am sure that your college is giving you the best education. If not, try to have more and more questions with your professors, extract more and more knowledge. That is the one aspect for getting the marks in the exam, because ultimately I will say that mark is an important factor for your career, for the further exam and other parts are concerned. But the education should not be only examinations oriented. It should be to have a deep knowledge of the subject which you claim that you have completed during your 3 years or 5 years legal course. And for that purpose, how you are going to do it? Any subject is concerned, you have two options. One, go for likely questions or small books 15 days before the exam. Go to class walas and have some likely questions or what are going to come, mug it, present it and have a good marks, and then you can go to the society and say that I passed in distinctions. Yes, that is one of the factors, but unless you understood the concept of all the themes of that act or the laws, your education will not be fulfilled or not will be the ideal one. And therefore, when you will come to the practice or you will expose yourself to the society, you must know that what is the basic concept of administrations of justice, what is the basic concept that faith society is having with the administrations of justice, and whether it will be helpful to grow in our economy when this is an era where free agreement of trade and treaties, and you are reading every day that we will have a multinational companies and other parts are concerned. But they want an assurance when they bring the investment. They want assurance when they bring their technology. They want assurance when their peoples are coming, staying here for the work and for various other places. Even for tourist industries, the tourists want an assurance of law and order in the country. So whatever kind of the growth in whatever field is concerned, everybody wants an assurance of good legal system in the country. You must have heard that on number of occasions advisories are given by the countries to travel or not to travel to the countries where law and order is worst or law and order is in the bad shape. And therefore, gentlemen, first of all, we have to keep it that for our economy of the nations, for ourselves, for the growth of the country, we are going to be a part of the legal system by our efforts, by our knowledge, that India will be one of the country in the world where everybody will say that India is a safe haven for investment, for residence, and what not. And for that purpose, when you are completing your course, 5 years law course or 3 years law course, during these 3 years, generally it has been found that only the legal education starts 1 month before the exam. And which practice, if it is there, you have to change it. I'm happy to say that number of colleges started practical training, calling guest lectures, professor of practice every month. They are trying to share their views or their knowledge, make available for the students, and students are also participating. But then, if it is sufficient, you have to increase much more also. And therefore, the questions will be that, say the law of contract, say the law of BNS, every part is concerned. Reading the definitions, reading some example is not sufficient. What we have been told that the legal system has been brought by Europeans in India, which is a false narrations. We were already having a good legal judicial system or justice systems. It was there. Only the thing was that with Lord Macaulay and other parts are concerned, they have made all the efforts that whatever in India was there, it was useless or it was little less, and whatever they were having the good knowledge, and they have tried to bring it in India to make a unified country, law-abiding citizens, and all these things which is not good, which is not correct, which we have to understand. And therefore, we have to read what was there before the Europeans came here, or before these systems of this penal code or the Evidence Act or contract and other parts are concerned. We were already having a contract. We were already having judicial system. I will give one small example that what kind of the system we were having. One of our district judge Morir was there. He gave an example that when he was in Dhule, a murder trial was going on, and who was the witness? The mother of the accused. So everybody was having a sympathy, and she was told before she came in the witness box that you have to say this, so that your son will be escaped from punishment of these things. She flatly said, हे न्याय मंदिर आहे, न्याय देवतेसमोर मी बोलणार आहे, मी खोटं बोलणार नाही. This was a word from a villager which she was saying, and this is the value which we were having since the beginning. Is it exist now, and if exist, to what extent? Nowadays, when you go to advocate, he says that all right, what you want. He doesn't say that what is your case and what will be the fate of it on merits is concerned. But he asks you what kind of order you want. There are only few lawyers who will say that this is a system where you have to go, whether to fight, not to fight, what to do, what not to do. And therefore, gentlemen, what I will suggest that besides your education in the classrooms, you have to go beyond the classrooms. This border of classrooms are concerned, you have to break it. You have to go to society. You have to have a survey. You have to talk to handcart driven persons. You have to talk to rickshaw driver. You have to talk to every other persons. And what is his view about the present judicial system? Come to the court. Have an interview with the clerks. Have an interview with the persons who are coming. Ask them what is your problems. Go to the other part of society, go to the shops, go to industry house and tell them that if there are disputes, what you are going to do. Gentlemen, still I feel, and it's painful, that in a big subjects agreements are concerned between two giants or corporates, one clause is there that if there is any dispute, there will be an arbitrations, and place of arbitrations will be Singapore, London, Sweden, and other parts are concerned. Why? Whether we don't have a faith in our system here, whether we don't have a faith in our judges here, ask questions to yourself. And ask reply from the concerned persons. For that purpose, I will suggest and I will request you that college should organize interaction sessions with the judicial system members, police administrations, and other administration systems who are in charge of it. There should be, without arrogance, without doubts, without making there any kind of allegations, you can ask, sir, we are reading in the newspaper that it takes 20 years and 30 years to prove innocent of the guilt or guilt of the persons. Why it is taking that much time? Because at present what has happened, that those who are in charge of justice delivery system, they are having their bungalow or flats, they are having car, they are having their good perks, and very few of them are thinking that we have to serve the society, we have to serve the nations. They say that we are part of system. And when we will ask them, they will say that, look, there are no funds given by the government for the additional courts. Look, in the Singapore, the proportion of the judges and the public is this. In America, that is this. All these things, they will give you the figures and they will try to say that ऐसा ही चलेगा. But I don't want our youth to say that ऐसा ही चलेगा. हम कहेंगे कि इसमें improvements कैसे होंगे? How we are going to do it? Because the questions comes that our former Chief Justice, I am giving you the responsible parts, go to US, make affidavit that Indian judicial system will take more time than American, and therefore the clause is justifiable that there should be an arbitrations in Singapore, London, or in the US. We should ask the questions to them. I think that there should be a forum. They should ask questions to those judges, and if they make statement after occupying the post of the Chief Justice of India or the Justice of Supreme Court, study them and make litigations or PIL to stop their pensions and all benefits which they are getting as a retired judge. Are we going to do it? For that purpose, first we have to equip ourselves with all legal positions. Legal positions, I don't mean that only the sections of the IPC and this part. So I am saying that you have assembled here with the concept that we want to build a good nations along with personal career. I will never suggest that go only for the building of nations and ignore your own career. But to have your career, why? We have to put questions to all these responsible persons, or make arrangement to have interacting sessions in their cabin or in their respective places. Can we ask the courts that why there is a delay to some extent and what procedural changes you can do it? Can we ask the police that why there is so much time taken for filing the charge sheet, which can be done within 8 days, 10 days, or 15 days? My dear friends, I can give you one example which was there when there was no technology, old typewriters, judges, without computers, no questions of email and all these things. Still, an incidence of murder occurred. From the date of incidence till the final decision, it took only 35 days. Now it takes 35 days to serve the summons. So the question is that take all this example. And if earlier this thing was happening, why not now? Have an example that in 1977, there was only one judge for the Pune district and Pune city who was in charge of the disposing the bail applications, and no matter was pending for more than 2 or 3 days. Then why we are taking 2 months and 3 months and 4 months? On the one hand, Supreme Court says that delay for 1 minute also in the jail or to keep a person is privilege of depriving him of his constitutional right. But then you are adjourning the matter for months together. Why? Take the case of an terrorist act, which we were earlier calling it MOCA and other parts are concerned. Why the arguments are going on for months together? We have to ask our questions that why other places are concerned, it is happening within a little of times. Why not in India? Why not in Bharat? What takes them? Why to say that any matter will be given the dates for a long times, irrespective of, and then they will say that the pendency part is concerned. So find out the formula. Nowadays there are technology, digital, online, chat GPT, AI, everybody is talking. Till today, I am not able to understand that whether this AI is to be used as a food or as a medicine. I believe that tailor-made justice is better than ready-made justice. We must understand why it has happened. So what we were saying earlier, there was a panchayat system, there was a jury system. What is meant by jury system? You must be aware, before this criminal law procedure code was amended, that 5 responsible, respectable judges of that city used to form a jury. There was a panel of 100 persons. Out of them, the judge used to select. So while appreciating the evidence, they used to assist the judge that what can be the legal parts. So appreciating the evidence are concerned, that jury system was there. But of course, some flaws grown, and therefore that jury system was abandoned and other parts are concerned. But then the questions comes that why the delay when all kind of the modern equipments has come? Why the delay of having investigations with the time and not in the limited times? Why the delay in arbitration system? You must have heard that there are family courts. The object of family courts was to dispose of the family dispute within 6 months. In the family courts, it takes years together. So you will ask me the questions that I have put so many questions before you, but what is the solutions of it? And for that purpose, I want this young mind to read from practical point of view and theoretical point of view the books, law books. I was just discussing and I was saying that with the simple things within the same parts, we can curtail the period of judicial trial. Go for the system of summons. I don't know how many of you have come to the court for practical training, but you will find that it has been said tarikh pe tarikh. Even filing the case and for first order is concerned, they will give a date for the arguments, for admissions, and then for orders and for all these things are concerned. When in 1972, when I started the practice, when we used to file a complaint, the judge used to read it immediately. No case is dismissed. There is a case for trial, issue process. There is a case for further investigations. Send it for the inquiry or investigations. Nowadays, what happens when you file the complaint, first it go to computer sections for numbers. It will take 7 days, 8 days, 2 days. Then the date will be given for advancing the first submissions. Then the date will be given for the orders. All these things are concerned if you are equipped with everything. And when you will join the bar, you can say that everything we have completed here and pass the order. Some of you may join the judiciary as a career. You will come with the mindset that I want to give justice to the society. And if you go and join judiciary with that mind, then that will be the bright future of India. Nowadays, the legal profession is looked after as a earning source. But yes, legal profession, but it was a professions with the grace and other parts are concerned. People were looking at it with the respect. As a lawyer, you are getting privilege. So don't compare your income with your brothers who is in the business. Because ultimately, if you are going to compare, then go to the business. Don't come to the practice or legal professions. Because here you have the privilege to represent and stand in the court and say so many things. Go to the society and say so many people looks at it with respect if you are a good lawyer. So if you want to have that privilege, then it will come with a duty. And the duties are concerned, you must be equipped with all the provisions. I was having one junior with me. She was fully prepared with the High Court manual, with the laws, and what is going on in the court. And therefore, even without paying any amount extra, she used to get all the things done within a recorded period. So the question is that if we are not prepared, then we go to the court, sir, please give me order. But if we are prepared with the case laws, we'll say that this is the things which are there. Supreme Court said that in the trial courts, they are passing the orders irrespective of what they want to do. If they want to, a number of cases where the proceeding should be stopped at the first stage by discharging, the trial courts are not doing that. So pendency is increasing in the higher courts. In the bail applications, the judges are not that much effective, and therefore they will pass orders one way or other, and so the pendency is increasing. So the Supreme Court is putting all burdens in the trial courts. The question is that some of you may go to the Supreme Court. You can insist for a practice and procedure that at least either one have to start from the trial court, lower court, or from the Supreme Court to have a improvement in the system. So the questions will be that how we are going to start. And therefore, my dear friends, you have to be supposed to be full equipped, and at a time you have to be vigilant with the politicians also. If the number of courts are required, you can ask the copy of the budget of the state assembly, how much income they are getting from the stamp duty and other parts are concerned, and how much they are spending on the courts further part. I recollect that there used to be a maximum 3,000 rupees court fee, maximum, and now it is 3 lakhs rupees. So the revenue is increasing. So whether that revenue is going for the perks of these MLAs and MPs, or they are used for the betterment of the judiciary, you study it. Bring the copy. Go to your MLA. Ask them that we want to have a copy of the budget. We want to read. We want to understand. Have a group of 5 or 10 advocates and read it. And ask questions to the MLA that whatever you are getting revenue from the court fees, from the fines and all these things, what is the portion you are spending for the judiciary and what portions you are spending for your trips and your perks and other parts are concerned. This is one aspect. The question is that when we say that in the past, that is in 1972, when without technology, if the matter was pending for more than 6 months, the judge has to give explanation to the High Court that why the matter is pending for more than 6 months. Now the answer will be that pendency again. So pendency is concerned when everything is given to you, what you have done for reducing that pendency. And these kind of the questions in an academic form, by having interaction sessions, we can do it in number of ways and other parts are concerned. The questions will be that all good practice we have to evolve. Talking to the clients, taking instructions from client in details, giving him an honest advice. Gentlemen, I will give you one more example that giving an honest advice, always paying you, you may have lose that brief, but your image in the society will be that your advice or your opinion is respectable. I was having a case of two industrialists, and they are having a dispute which was because of the misunderstanding. I called both of them. And when they both came together, they talked and they found that the dispute could have been resolved simplicity. Why it was not resolved? Because the person who was a manager of the factory was from the north belt, and you will find that Sala is a normal shabd. It is not an abuse. But he told the other side, "Arey Sale aisa hota hai bhai sahab, kya Sale aisa karte ho?" So other side said, "You have abused me," and the matter increased, and that gone to the bottom. What was the dispute? Use of the FSI of the plots. 10 plots were sold. If jointly it would have been plan sanctioned, FSI would have been more. The landowner would have got more amount. Otherwise not. The other said, "I am ready to do." And he said that you have your architect, You have your solicitors. I will deposit the checks, and whatever FSI you are going to get, I will pay for it. Settled? Then that developer came here. बोले साहब मैं क्या वेड़ा है क्या? When there was an agreement, it was a X price of the FSI. Today is 10X. So if they are going to get it sanctioned, all the FSI, I'm ready to pay them because the amount. So look, to bring both together, I have lost that brief that I could not file the suit. But then both the sides sent me 10 clients and my work has increased by 10 times. So you should be faithful to the client. The second part will be that you must have a adequate knowledge of our mother tongue so that you can have interactions and have a good part of information which will help you to come to a right conclusions. The third part will be that develop good habits, early riser, coming in the office and give good service to the client, because earlier concept was that client used to come to advocates with the feeling that client does not know anything and advocate knows everything. No, client knows everything. He knows that whether my advocate has read the papers, he is well briefed himself. And you can't bluff your client because no, they are also equally educated. Fourth part will be that your efficiency. And I will give that example and I may stop here because everything's are there. What kind of the efficiency now the society and industry is expecting? Before that, you can go for the group cultures. One advocate, one clerk, office are concerned, of course, they will have their practice, but there is a limitations. With the international market and multinational companies entry, they want all under one roof. And therefore, you must have a group cultures working in field of all aspect of life. Now, on the point of efficiency, let me tell you that I was having a little bit feeling that I am very efficient. So whenever the people used to come, I say that within a day or two, I used to work for their draft and other parts. I went for a conference in one of the industry's executive's office. And gentlemen, you will believe that within 10 minutes, conference over, he gave me tea and idli, and within 10 minutes, I was out with full satisfaction from both the sides. How it has happened? Because the concerned officer with the papers, with the stenographers were sitting there. Whatever I was saying, that was dictated. And immediately everybody was out and the next person was waiting for entry. So I thought that no, I have learned the efficiency. So next part come when these mobile companies came here, mobile phone and all parts are concerned. And one of the officers came to me and he said that, Mr. Jain, what kind of the fast service you can give? I said, yes, I can give. You give me the documents today, you will get tomorrow the draft. You give me your comments and the next day you can. So I was thinking that I am one of the efficient advocates. He said that, sir, we have not come here to work with the days and hours. We are here to work with the minutes and hours. And the reason was, he told me that they were paying 300 crore rupees license fee per year, and the delay of project for one day will cost them 1 crore rupees additional expenses. So they said that, sir, we will send you the paper in the morning. We want a draft in the afternoon. We'll send our comment, and the evening we should have the final draft for executions. So that kind of the efficiency, that improvement was there. So again, I thought that, no, I'm very efficient. Then the next time, one of the multinational companies executives asked me that he want to discuss some matters with me. So date and matter was fixed. 2 days earlier, the PA called and he told me that, sir, you have a meeting with your boss and all these things. I said, no, he has a meeting with me. That was in a lighter tone. But ultimately, it took 4 or 5 phones talk. And then ultimately, he came to me. I was having the file with me, and there was discussions and everything over. While standing, he said, Mr. Jain, in your file, there were 15 papers. We have to discuss only 2 papers. If you kept these 2 papers above it, both of us could have saved 5 minutes of each other, which can be utilized for better work. So see, this is the way in which the society now wants the efficiency from the advocates. And if these services are to be given, you have to develop all good habits. while sitting in the office, you must be ready with the papers and everything, and ready to give reply to the questions. So the question said that this legal system is concerned, as I have said, that to make India one of the best place for the investment for multinationals, satisfactory reply solutions of our Bharatiya people, and as and when it will be a good judicial system, automatically the corruptions will be reduced. Why corruption is there? Corruption is because of the one of the important causes is the delay in trial. So if there is a percentage of corruption is less, again there will be a good system. So, gentlemen, what I will say that I am expecting from you in deliberations, by using AI, by using Intellectual Property Act, by using good practices, how you are going to make India a good country, an example for the world at large, from the point of view of economy, administrations, and justice. And I have no doubt that because you have listened to me for about 40 minutes, so you have a desire at least to be a very good and leading professionals, and you will be. With these few words, let these deliberations for 2 days remain. I will request the organizer that it should be going on, and the students of each college should be, what I will say, that encouraged to look beyond their curriculum, beyond their books, read the practical theories, read the communism, capitalism theories, read the theories and other books are concerned on all aspects. No, it's a question of interdisciplinary. An advocate is supposed to know the medical science, an advocate is supposed to know the engineering science, an advocate is supposed to know the commerce and accountancy. So your role will be important, your role will be, and you will have the importance depending upon how much you have gained knowledge during your career as a student and thereafter. Thank you very much for listening me, and my best wishes for the deliberations. Jai Hind, Jai Bharat, and Jai Maharashtra.
Good afternoon to everyone. And it's a proud privilege for me to come back to my own alma mater today. I passed out from this college in the year 1995. And I distinctly remember, and I have vivid memories of sitting in this auditorium amongst you people, listening to the speakers, trying to understand how the destiny of the legal profession is going to be shaped in the future. Back when I was a student at Symbiosis, I also remember Apple had just launched the iMac and setting off the trend of desktop computers during that time. And today, when I speak to you about artificial intelligence and its regulation, and also about what it means to be a lawyer, a regulator, and a policy maker in this consequential age. Last week, I was honored to be on a panel at the Harvard Business School in Boston. And the subject we were discussing at that time was AI and its consequences on the law and on lawyers in the background of the conference's overall theme, which was the India we imagine. With each panel discussion, what increasingly became apparent that India is at a remarkable inflection point. And as I speak to you today, I realize now that you are the India that will take it forward. For much of the last decade, our posture on emerging technology regulation has largely been wait and watch, while also to carefully listen. The lesson that India has drawn when it comes to AI is not drawing from EU or from America. Instead, India has chosen a middle path, a path to support our vision. This is through a flexible, pro-growth model that treats innovation not as a risk to be managed, but as an instrument of development, inclusion, scale, and ambition. India's AI governance guidelines and the subcommittee report that our advisory group had helped shape echo this thought. The first step in the process to build a regulatory environment for AI is to recognize that innovation and safety are not opposing poles, and we must choose to enable innovation through safety by adopting an outcome-based and risk-proportionate approach. Just to give you an example, sorry, this is a dry subject, but let me dig deeper into the subject. Like, you are all aware about the deepfakes or the artificial intelligence video. Now, when we are talking about the safety of the people, those who are going to consume the videos and the impact the video will have. The idea is not to be afraid of the deepfakes. Yes, if there are deepfakes, the problem is there. We will deal with the problem, but at the same time, we will also not stop and we will encourage the innovation that is going to take place in the field. And therefore, when I say that when we speak about AI and the regulation or the infrastructure, it is not just about innovation and safety, innovation or safety. We are talking about innovation through safety. This is a very fundamental principle one should know. So basically what we are doing is we are focusing on the outcomes rather than the underlying math, and we are keeping the door open for the developers. We must thus regulate AI simply as an infrastructure and not as a threat. The question then automatically shifts is from what could go wrong to what should we engineer for things to go right. This is a very important question, and if you are aware, in the last 5 days in Delhi, if one question that is being discussed is, should we be afraid of AI? Is AI safe? So, and what can go wrong? So the focus of India, the focus in India, or when you speak to the developers or people who are in this sector, it is not about what could go wrong, but it should be what should we engineer for things to go right. We must build an architecture of agile governance. So what does good governance and agile governance really look alike? First, broad principles established by legislation. India's AI guidelines speak of 7 sutras: accountability, safety, transparency, fairness, privacy, explainability, and robustness. This form the constitutionally grammar of trustworthy AI, and they envision the fundamental principle within which AI must develop. Secondly, it is also important to ensure that implementation details such as technical standards, compliance thresholds, and sector-specific rules must live in subordinate legislations such as rules, advisory, and guidelines. Now, let me explain to you one more concept. When we speak about the law, I mean, apart from the constitution, you have always looked at the statute and everything, then statute followed by rules and then the regulations. So one debate, and this is a fundamental debate when it comes to the technology law. Now, if you would have noticed that somewhere along 28, 29 years before, we had introduced the Information Technology Act. At that time, when the Information Technology Act was introduced, it only covered issues like digital signatures and e-contract, e-signing and other aspects are digital signings are concerned. But as you see, the technology has developed from Web 0, we are now Web 3.0. And when we are looking at Web 3.0, the technology is going to evolve. The policies are also should also evolve according to the evolution of technology. So therefore, the principle is, and the principle that is being debated, and since you are the law students, you should, and there is a debate that comes is, for the technology laws, should it be hard-coded, where everything is drafted in the beginning, or you lay down the principles and leave the regulations to govern the sector? This is the one area which should be, reflected in your discussion also. Second, it is also very important to consider that as the technologies are emerging and constantly evolving, our legislative process are long and require a law to go through several hoops before finally being notified and then actually enacted. The capability of a large language model today is qualitatively different from what it was 18 months ago. Highly autonomous AI agents are demonstrating new capabilities that may require rethinking entire governance categories. Legislation, therefore, in the field of AI must be flexible enough to absorb that change without requiring amendment after amendment. Third, we have to also build regulatory sandbox that allow for experimentation within a supervised environment. Now, as a law student, you may find regulatory sandbox as one of the dry subject as to what is this regulatory sandbox. But I think I will urge all of you to look at this concept of sandbox. And when we are talking about different kinds of risk when it comes to AI, and you have to test those risks and you have to see whether that technology is going to be safety, such risk you have to allow the innovation to be tested in the sandbox method. This is going to be one very important subject for the law students to note. It is not, sandbox is not for the developers and all, but it is also, I will urge the law students, all of you, to look at the sandbox method and read and find out more about the sandbox model. A regulatory sandbox allows innovators to test, fail, learn, and iterate with real feedbacks from regulators, ensuring human in the loop, safeguard sandbox first, and criminalization last. It is the sequence which separates enabling governance from the punitive governance. So one of the questions that is being asked is, like, what is it about AI? And what is it about the regular governance? So when we talk about safety first, the principles of liabilities to be comes the second part, and as far as the criminalization is concerned, when you look at the regulation, you will see that will form the last part and not the most important part when it comes to the AI regulations. Lastly, when I come to the regulations on AI, we come to the question I'm always asked: does India need a new AI legislation? My answer is simple: not yet. We do not need a new AI legislation. When enforced consistently and interpreted purposively, our existing laws on information technology, data protection, consumer protection, and criminal liability are sufficient to govern the AI applications. Now I am coming to the second part of my talk today, and the most important aspect is how does AI really impacting you and going to impact you as a lawyer and insofar as the judiciary is concerned. When it comes to the judiciary, my personal view is that the word artificial intelligence is actually a little misleading when it comes to the field of law. According to me, when it comes to the law, it is when I frame AI, then it is about augmented institutional intelligence. And when I say augmented institutional intelligence. And when I say the term AI is misleading, what does it mean? India's AI movement is unique. And when it comes to the law, lawyers, and the judiciary, it is not about replacing lawyers or building algorithms for the judges or building algorithmic judges. It is about managing scale and reducing friction. AI, when it comes to law, judiciary, is about scale, reducing friction. Now, when I say about the scale, what do I mean about the scale? You are all aware about the massive delays that are pending in the court. So AI can be used, and AI as a tool can be used to deal with the problem of the backlogs and the delay. We are dealing with multiple state, multiple language. So when it comes to AI is about translation. Like you are arguing, you can be in any part of the state, you can speak in any language, a person can understand in whatever language you are speaking, irrespective. So that can be an answer to your regional barriers also. So AI is going to be about that. And when I'm talking about reducing friction means reducing backlog, reducing caseloads, making sure efficient judiciary takes place, making sure the translation is in a good speed, making sure we have the transcript of the entire proceedings. AI is going to be about that. Now, last month, the Bombay High Court delivered a judgment that I think every law students in India should also be aware of. The court found that one party had submitted entirely AI-generated legal arguments, replete with fabricated case citation, hallucinated precedents, and what the judge described in the judgment as green box tick marks, bullet points, and repetitive submissions. This was a factual thing that has happened in the Bombay High Court, and 3 days before you saw the same situation where the lawyers are just going on the large language model, getting the submissions out and throwing the petitions and the submissions before the judges. So these are the obvious signs of AI generated content. The judge and his clerks, and this is recorded in the judgment, they spent precious time attempting to verify citations that simply did not exist. The court's observation in the case was pointed. AI tools must be used in aid of research, and human oversight is indispensable to ensure that what is submitted is genuine, verified, and relevant. My dear friends, I can tell you once, a question is always being asked, like, so what is the future of the AI, and will AI replace the lawyers? My answer is very simple, that machines will not replace human beings. But those human beings who cannot use the machines, they can certainly be replaceable. The next point is that the future of legal practice is clearly and most definitely not AI versus the lawyer. I see it as a hybrid model where AI performs the high volume tasks of research, summarization, and transcription, while a lawyer provides the judgment, strategy, knowledge, training, and even empathy and skills which no model can replace. So basically, when it comes to the law, it will all be about, and the lawyers, it will be about the judgment and not about the drudgery. Think of it this way. You must learn to use AI in the capacity of both a junior and a senior. As a junior, your AI tool can take notes, draft memos, synthesize research across thousands of documents in a minute. As a senior, it can test your arguments, flag inconsistency, and assist with strategic thinking. But the fact is, having said that, the human oversight should not be and must not be ruled out. The skills you must develop, therefore, is not just how to use these AI tools, but also when to trust them, when to question them, and when to override them entirely. What I find genuinely exciting about this movement, and this is something you must all use to your advantage, is that AI is collapsing the distance between access and competence. A small two-lawyer firm in a tier 2 city in India today can access the same depth of legal research as global firm with hundreds of associates. Now imagine earlier what used to happen. The senior lawyers, the big firms, they used to get an access to the tools of research. To that extent, AI is going to democratize, and the language you can use, the language you can use for the drafting, the research you can get is going to be at the same level. So it provides a level playing opportunity, and you can a two-lawyer firm or even a single lawyer can sit and compete with 1,000-lawyer firm in wherever or whichever part of the world. A lawyer whose first language is not English can also draft high-quality contracts, structure complex arguments, and communicate with precision and language that would previously have required years of expensive mentorship. However, as with every advantage, this democratization comes with a corresponding responsibility. If AI gives the tools of competence, then what differentiates the truly excellent lawyer is not access to information, but by what they well know enough to question and are wise enough to apply the law to the specific situation. These are not the skills that AI will develop anytime soon or ever, and they are thus precisely the skill I am urging you to cultivate with rigor. You are all entering this profession at a moment of extraordinary consequence. The legal framework being designed today will govern AI for generations, and you will be the one who are going to argue these cases, draft these regulations, counsel the clients, and even sit on the benches in the future. India too is moving deliberately and intelligently. It has gone from wait and watch to build and lead. The law has always been at its best an instrument of imagination. In the age of artificial intelligence, that imagination must be sharper, more agile, and clearer than ever before. I look forward to the India you will help build. Thank you very much.
Sir, thank you so much for this insightful session. With your permission, can we take a couple of questions?
Can you please tell me your name and the college you are representing?
Good afternoon, sir. My name is Harsh Bhagat, and I'm from Shankarabraman Law College from Pune, sir. Sir, I heard you speak in the first part of your speech, and one question you asked yourself was, does India need a new AI legislation as of now? And you said not yet. Today, AI is used to commit crimes like harassment and create deepfake videos and images, and also, as you stated, by submitting imaginary citations in the court. Sir, so what would be that crime or what would be that point which will make you think that a new legislation for AI is needed in the country? Thank you.
When I answered not yet, I also went step forward that the existing laws are good enough. So if you will look at DNS, it deals with the various issues of harassment. It also deals with the issues of deep fakes. If you will look at the intermediary guidelines, recently we have given the labeling guidelines, and there is an obligation on all the social media intermediaries to label the deepfakes and everything. So the existing law and regulations have provided the safeguard, and therefore I am saying that as of now, we do not need any hard-coded legislation. We want the technology. As the technology will evolve, the law will also evolve when it comes to the artificial intelligence. Thank you. Yeah. Go ahead.
Hello, sir. Good afternoon. This is Ishan Sahu. I'm from Symbiosis Law College. Even, sir, I have the same question. As you mentioned, the laws are sufficient, but sir, when it comes to the penalties and about the recent, like the guidelines which are mentioned, but still, sir, we are lacking so many things when it comes to the EU and the US about the GDPR, like professional, like properly mentioned the provisions and sections related to AI, deepfake, and cloud processing. So, what is your opinion?
I think what you're speaking is about the implementation, because we are talking about so that also I've covered in my part, that it is all going to be how we are going to be implementing this legislation and the regulations and the learning. And as we learn from them and as the situation will arise, the solution will also emerge.
Like, sir, I'm not discouraging, but don't you feel like we are lacking so much when it comes to the cyber? Like, as compared to GDPR?
Well, that can be your subjective opinion. Next question.
Hello, sir. Hello, sir.
One question from here, then I'll come to.
Gina.
Good morning, sir. My name is Hema Thakar. I have been a working professional. I have worked with Tata Group and KPMG. Currently, I'm an entrepreneur, and I'm a part of an incubator. And I'm working on a concept of human and machine interface with respect to the emotional challenges that humans will face maybe 10, 15 years down the line while dealing with the workforce which can be humanoid robots. So I would like to have your perspective on the challenges that we will face as the owners of the company. Or you said either you are a consulting firm or you are a law firm, and you are dealing not with your associates but perhaps even the robots who are doing manual work, or even dealing with the robots or very, very advanced machine learning systems. So what could be the challenges that professionals face in terms of cognition, because they would be advancing from normal data analytics to something which is of a higher level. So I would like to have your perspective.
Well, it will all depend. See, the challenges come right from the first aspect is the protection of the intellectual properties. Second thing, as I mentioned to you about the risk the humanoids or the robots can possess, we have to test this risk, whether they are high risk, low risk, or they come in the prohibited risk categories. For example, nowadays, I was just looking at some videos which was showing about humanoids using the arms also. Now, this may come into the case of a prohibited risk altogether. So basically, when it comes to the intelligence and the application, we have to create an environment where we have to test this risk. The most important part, and therefore when I mentioned in my speech, that it is not about just innovation and safety or innovation through safety. Yes, companies like you are there who will be looking at innovation, and you would like that innovation to be promoted. Now, the only question is that whether our regulations are rigid, that you have to take the permission and then innovate. So today the systems allow you to innovate, and it will continue, and side by side it will regulate.
Hello, sir. I'm Nia Deshpande. I'm also from Pune Law College. We were talking about how you said that humans that won't be able to use the machines will get replaced. So I was just wondering, as a law student currently, what are the skills that I can improve on with respect to AI? Because even last year I was interning at a firm and they were developing Harvey AI. So what are skills that I can create or build upon that would make me useful even on that end of things, on a more corporate side of?
I think you have to, if the same question that was asked me, and when I was asked a question in Harvard, like if you want to use that one AI tool, what should you use for? And my answer was that I use AI tool for pattern recognition. You know what is the meaning of pattern recognition when I say pattern recognition? Say for example, there is a particular bench. They are dealing with the subject of writ petitions or commercial injunction. What is the view of that judge? Whether he is a pro relief or a negative relief. Whether he is a liberal judge or whether he has a different mindset. Whether he is a pro bail or whether he is an anti bail. Whether he is a pro injunction, so you can study the pattern, so AI can help you get the pattern recognition. Second, it can help you and it can aid you in your research tools. But having said that, don't blanketly rely on the research that is thrown by the AI. You have to cross-verify it with the references, because at the end of the day, what is AI about? AI is about the data. And the data that is being fed, if the wrong data is being fed, you are going to get a wrong research also. So you cannot blindly rely upon the research. The most important tool where AI is being used is to make summaries, prepare translations, transcriptions. Transcript and translations are very important, particularly in a country like India with multiple languages, different states, and transcription gives you an accurate record of the proceedings, so which it makes the proceedings transparent and accountable. Thank you.
Thank you, sir.
Namaste, sir. I am from Modern Law College.
Can you please speak in the mic?
Namaste, sir. I am from Modern Law College. My question is slightly different. AI hype is created in this India. So I am thinking about job opportunity. Means it's not job, it's this occupation, this said advocacy occupation. I am thinking that the legal law firm will take the maximum cases, litigation cases from this individual practitioner, because they will have a high infrastructure legal firm. So is it not a means will create a job loss for this individual practitioner?
On the contrary, AI will help a firm or a single lawyer to compete with the larger law firms, as I mentioned. For example, what is the differentiator? Suppose I am a client and I want to choose a lawyer. What is the differentiator between two lawyers? Forget about the big, small, or between the two lawyers. Can someone answer that? Suppose you are a client and you want to appoint someone to represent you before the court, tribunal, or you want him to draft. What is the differentiator you are going to take? See. Okay, source. Next.
Minimum time for litigation.
Societal event. Next. Experience. Next. Specialization. So as far as special, now let us come to one more thing. Can a single lawyer not give you the same solution which the large law firm can give?
No, sir. Because
Of course it can give, because your tools of research is going to be the same. You can specialize, you can use the same, the tools will provide you to specialize. According to me, AI is going to be the most democratic tool. Yes, 20 years before or 30 years before, like if you used to go to the Supreme Court or the High Court, what was the differentiator among the senior lawyers was better access to the library, better access to the books, better access for the speaking opportunities, better tools of learning. Now these tools are all going to be available at a much cheaper price. So in my view, people should not be afraid of AI. AI will not replace the jobs. As you see, the technologies, they keep on evolving. But as the technology evolves, so do the human beings and the professionals evolve, and it throws up the new opportunities. Next question.
Hello. Frankly, I love the way you speak and very straight, sir. I really appreciate. Thank you so much. I am Rakhi Sonore. I am a LLM law student from the Modern Law College near University. So my question obviously not in technology, because I also belong to the IT background. Almost 22 years in working in corporate. So I will ask you normal questions. What is that one case, which touched your heart and emotions, and you were satisfied saying, yes, this is what, I got it.
I think number of cases, because when you can see the smile or the joy on the face of the client, I think that gives you the satisfaction. It can be a satisfaction when someone gets the possession of the house. It can be satisfaction about someone winning a commercial battle. It can be satisfaction when you represent a sports person. It can be satisfaction when someone you represent from the industry. So I think it is not about like this thing, but I think the satisfaction comes from the fact that you are given 100. I have always believed that a lawyer cannot decide the fate or the results of the case. I think what is in your hand is the effort. And if you are satisfied that you have given 100% of your effort in the matter, I think that satisfaction that I have done my best, I think that gives me the greatest satisfaction.
Thank you, sir.
Last question.
Good afternoon, sir. My name is Rishabh and I am from Yugantar Law College. So my question is simply that, according to you, should AI be integrated in our judicial systems? Like, suppose an argument is going on, so AI can check it, the argument, and then it can integrate it. And then also when a judge is a human at the end, and human can be biased by its thoughts, by its opinion, and all. And at Supreme Court and High Court, we have some judgments like which can impact the whole society. So AI should be integrated at that point to make so that the judgment should not be biased and all.
Can AI not be biased?
But at the end, AI can be biased, but not when we compare to with a human. It cannot be biased as a human because AI is not. AI has no motive to be biased.
Ultimately, from where is the data being fed? And who's feeding the data?
But
where is the data? What is the source?
But at the end, a human would be more biased than AI.
I will tell you, the data that is being fed is by the human only. So there is one side is the human and the other side is also the human. All right, thank you very much. It was a good session. I enjoyed speaking to you. Wish you all the best.